feel free to use them as you see fit, but those not ours, and I don't quite understand it. The agenda for today's show here. We're going to cover several preliminaries, and then there's internal transitions, basically where you transition ownership to younger members of the firm as the rest of us kind of fade out. And there's also external ownership transitions, entirely different types of transactions. External, sometimes called M&A, mergers and acquisitions, which are almost always an acquisition, but we call them mergers and acquisitions, or third-party sales often used. That's what we're talking about there. So we'll cover, after the preliminaries, both internal transition, which is one whole program, and then external transition, third-party sales, which is another. Okay, preliminaries, we'll cover these things. I want to talk briefly, maybe not quite so briefly, about shutting down a practice. Another issue, preliminary, you just have in the back of your mind is entity selection. Every firm needs some sort of legal entity. You can have a partnership, but you shouldn't. And for liability purposes, if nothing else, that's a disaster. So you're going to have some sort of corporate entity, and some are better than others. Some are allowed, some are not allowed, not legally, but because of the Practice Act, you can't practice architecture in them. So a brief little tutorial on entity selection, which seems to be one of life's mysteries. So we'll sort that out some. And we'll talk about value in a practice. The common question is, how much is my firm worth? Interesting question, terribly naive. There's a lot to be said about that. So we will kind of, again, back to the sophistication point here, ideally give you a better idea of what that really means, how you'd answer that question, in what context, for what purpose. Right? So that's the show we have in mind. Talk now, shutting down a practice. We used to think, I started one time, this was kind of the third way to do it. You just, if you, at the end of the road, you just close your practice and move on. I was much younger then. It didn't take long to figure out that shutting down a practice is not a plan, it's a failure. It's nothing but a loss. So there's several aspects of that which keep in mind. And you can do it, by the way, and I've had friends and clients who've done it, but this is not recommended for several good reasons. So gets back to the inevitability, you're going to have to deal with transition. You can't just close a practice because you lose a lot of the value, and you also have to get off the tiger's back. A firm that could have supported you and your family for decades as a real valuable asset can become a liability overnight. So you don't shut them down. So why not just take the shutdown route and buy a ticket and go to the south of France and live happily ever after? If you shut it down, you will lose a lot of value. First of all, everybody has accounts receivable in various stages, et cetera. And eventually we mostly get paid. But when you close your practice, if people see you're out of business, you're not going to get your AR paid. Sorry. Been nice having you around, but you've lost your leverage. Goodwill. We'll get to valuing a firm in due course, but a lot of that is what accountants would call goodwill. There's just extra value to having a going concern, client-based procedures, people, track record, as opposed to just chairs and computers or whatever. It can be very valuable, multiples of the book value of a firm. But you close the practice, you just lost that. Your reputation, worthless. Your stuff. When we moved our office a couple of years ago, I was going to give away some office furniture to charities. And it turned out I got a $10,000 bill to carry it off the property. I mean, no one wants your stuff when you're closing an office. Your portfolio, people who have been doing this, firms that do this, have, whether they know it or not, a very valuable copyright portfolio, design portfolio. Can be very valuable if you know what it is and how to use it. Close the business, you just lost your portfolio. And fixed assets, don't even think about it. I mean, they're just you're gonna have to buy out of your lease, et cetera. It doesn't work. So The downside of it is you have something that could be valuable if you handle it properly, that just loses all its value. But there's more.
All right, so if you're forced to do a shutting down of a practice, there's going to be some liabilities. And these liabilities would come into other play, internal, external, but they're going to be more pronounced in the shutting down of a practice. So you may have leases that are either ongoing and or have personal guarantees. You're gonna have to figure out how to either buy out of those, close them down, those sorts of things you would have to make sure are done so that the landlord doesn't sue you and you end up with a judgment, and hopefully not against you personally. The professional services contracts can be an issue. Who's going to provide the continuing services? How are we going to make sure that that client gets serviced? And then there's the ever lingering indemnification provisions. What happens if what happens if we're sued after we shut down the practice? We'll get into the kind of the liability tail ways to protect that. But the professional services contracts are always a source of consternation, whether you're shutting down your practice or you're selling your practice. So, and it's a liability here as well. Your employees, have they received final payments? Did they get their vacation pay? If we don't get that settled, they can make claims, and potentially, in some cases, they can sue individual officers. So especially if you carry the treasurer office, you may have had to shut down your practice, but you may still have liability under California law, at least, as to unpaid or improperly paid employees. Then there's the ever-present administrative burdens when you shut down your practice. Final tax returns. What am I going to do with the benefit plans? Getting the notices out, making sure you have handled the rollovers. What am I going to do with all those project files? What are my obligations under the law? Where do I put them if I still don't have, if I have paper versus electronic? And I don't know about the rest of you, but I still have a lot of paper, maybe less than I used to, but there's still a ton of just paper. And then once all that stuff is taken care of, making sure that the corporation has been properly dissolved under the law, so we can start the tail end of the ability to get sued on the corporate level. It's important to note that if you are shutting down your practice, you still have fiduciary obligations. We talked about one on the employee side. As an officer, you also, if you're the majority shareholder, you've decided to shut down, you also have potential issues with the minority shareholders if they feel like they're being treated unfairly. And then clearly, there's always a fiduciary responsibility with respect to payment of taxes and taking care of your creditors. I remember when we were shutting down practices, I think in the last recession, we would put creditors into two piles: creditors with personal guarantees and creditors without. So that's just something that would have to be part of the process. Then finally, and Mike alluded to it, when you're shutting down your practice, if you don't think about, or you can't afford, or you don't do anything, you have this extended liability tail to the extent that you have not just signed and stamped plans, but acted as the responsible architect or engineer in charge of that project. And that's what the law says. So there are ways to do that. We'll talk about different ways if you get sold, but in the most obvious one for a shutting down of a practice is the extended reporting period that they call it, also a tail. Sometimes people still call it a tail, but it's the extended reporting insurance. I don't want to be, it's typically there. Most policies include it, but note that it can be really expensive depending on how many years you go out. So if you're thinking about doing that, you probably should talk to your broker about what that's going to cost. And then finally, if you were going to shut down your practice in order to do something to try to protect your personal assets, you'd probably want to do some asset protection with some sort of an estate planning attorney. And the reason I say that is you can do asset protection as long as you are not do not know of any claims. Once you receive a claim, if you transfer assets out of reach of the creditor, it's called a fraudulent transfer, and they can bring it back in. So anyway, a few things to think about if you're going to go down the road.
Let me take this chance to disabuse a couple of common misunderstandings about the liability tail. to begin with, there is a notion, Michelle just mentioned it, if you're the one that signs and stamps plans, you've got the highest profile. So, and you're the easiest one to find if some tort guy wants to come after you later. But that's not the only person who's liable. If you provided professional services for a project, you're liable for what you did, even if somebody else actually signed the plan. So there's not, don't take comfort in the fact that you didn't actually sign the plans. If you actually provided the services, that can be a problem. The other thing that's real and often misunderstood, people hear about the statute of repose, 4 years for patent defects, and then 10 years for latent defects. So after 10 years, I'm safe, right? Because the statute of repose, 10 years, not from when I finish, but from the project finish. So maybe 12 years after I finish. But at some point in time, we close the books on that. I've been doing this for 30 years, 40 years, and I don't have a 40-year tail. Actually, you do. For the statute of repose, the 10-year statute of repose, it does not apply to personal injury or wrongful death actions. Read earthquake damage or fires that come up later, that sort of stuff, where people are injured in the building. And this can be anytime. There's no duration on that. So your statute of repose or statute of limitations really for your practice, for your tail, is not 10 years. It's not 12 years. It's 1 year after the date of death. After that, you can breathe easily. Until then, you are subject to liability for the service you provided over the course of your career. You heard it here first.
They're still here. They didn't leave.
Maybe they did.
Maybe they did.
We can't
All
tell.
right.
Right. Now,
Entity select. So again, these are preliminary. I'm gonna pull some of this slide back later when we talk about selling to third parties. But I want to be really clear. One of the things that I'm typically faced with in a transition, especially a third party sale, is how you are practicing architecture and engineering. I've had many discussions with lawyers. So let me tell you the way it works in California. You can do business as an architect or an engineer in a corporation. It can either be a C corporation or an S corporation. What are those? The C corporation is, if you've heard about dividends like Coca-Cola, they basically, the corporation itself has to pay taxes. And to the extent that it distributes profit, it pays a dividend. Most architects do business under an S election, and an S election is a pass-through tax entity where all the profits and losses kind of flow through to its ownership. And since architects typically are practiced through individuals, the S corporation is very popular because an S corporation can only be owned by individuals or kind of the revocable living trusts. So let me do that. You are also allowed to practice by via like a partnership or an LLP. The limited liability partnership tries to provide some sort of corporate protection, some sort of entity umbrella protection. The problem with the LLP is they keep extending the deadline for which you can do it. And it's very cumbersome to make sure if you are meeting their insurance or their security requirements. So a lot of people kind of either, if they're a general partnership, they might have partners who are corporations. If they're an LLP, we talk about it a long time before they elect to do that because there are some more paperwork. It's more paperwork intensive, at least at the state level.
Let me do one thing on the entity selection here. What we found is the slide is talking about California law, but especially with the M&A sort of practice, more and more we've got buyers from out of state or we're going out of state. And so we're crossing state lines and different state laws apply. And the state laws are different in terms of what entities are allowed and how they work, and especially in terms of the practice acts. Every practice act is kind of the same, everyone is different. So we got 50 of them written down here because that's how many, I think it's how many states are, yeah. So
Currently, yes.
Yeah, and they all have little twists and turns. And what I've just found personally is people want to use cleverer things here, like you can use an LLP here now until it sunsets, and so it sounds sexier or something. But it discards problems down the road. Keep it simple. A good S corp goes anywhere and can do it. But if you're doing the sort of thing, I don't see any real advantages. Maybe there's some tax things that I don't understand to having complicated or unique structures here. Basic corporation, almost certainly an S, easy to do, cheap, easy to maintain, no tax liability for it.
And yeah, we'll get into the
Right.
regulatory issues when you go across
Yeah.
state lines, that we'll talk about that later. It doesn't really apply on the preliminary side. Somebody asked a question about the difference between a C corp and a professional services corp. Well, it's actually just a corporation and a professional services corp. So professional services corporation is going to be a corporation that has elected to be governed by the Moscow-Knox professional law in California. And that just means there's an extra layer of ownership. So the ownership can only be owned by like licensed architects. So it's going to have some restrictions to who can own it and who can govern it. It is not very popular in California because a lot of architectural firms want to bring in non-licensed architects to be owners. And in California, under its regulatory guidelines, non-architects can be owners of a C or an S corporation. That is not always true in other states, but in California, the corporate law here is very flexible. So I hope that answers your questions, but it has to do with ownership and control and kind of limiting it to the licensed architect or the licensed engineer. I want to do one shout out on LLCs in California. LLCs are great. People love them because it makes it easier to divide profits. It doesn't necessarily have to be percentage of ownership, which it does on an S corp. But they are not available to practice architect or engineer or actually any licensed professional service in California. I've given you the codes. Again, just over and over again, but these are the specific codes that address that LLCs are not available to practice architecture or engineering in California. And I will point out that includes foreign LLCs that are trying to do business here. That will come up later when we talk about business structure and trying to make sure that your external sale is properly set up. Okay.
Now, take a breath, something new. The third preliminary here. Whether you're going to do an internal sale or a third-party sale, the questions are up of what is the price? What's the firm worth? And this again proves to be one of life's mysteries. And I think the important thing I want to do in demystifying is I don't have an answer, and neither does anybody else. And if I was going to give an answer, it would depend on circumstances and goals. It's not written in stone. It's not a physical fact. It's a result of decisions you make on business plans and that sort of thing. So it's a wide open process. People can look at a firm and look at the revenue or so-called EBITDA, and in general give a rough rule of thumb of 2 or 3 or so much of book value in very general terms. Anything that matters, it's a detailed question in terms of time and particulars of the transaction you're dealing with. So there ain't no answer. That's my point. There's ways to get answers in particular situations. There is not a legally prescribed method. I want to do this to the IRS. The government's going to want to know the value of my firm. How does the IRS value a firm? Well, it doesn't. It doesn't have any way to do it. It's wide open game. So if you're looking for the legal answer, you're out of luck. Right? There's no one size fits all goal. If I'm anticipating an internal transition, I don't want a big price. A, people don't have a lot of money. B, every time you do that, there's tax consequences. And the bigger the price, the bigger the consequences. So you give more money to the government. That's not necessarily a good thing. Maybe you want a lower price. Well, if I'm in a third-party sale, screw the taxes. I want the best price I can get. And those are different different goals, different methodology. So it varies with what you're trying to do, what's your business plan for transitioning out of the firm. Okay? Uh, People want a fair price. Yeah, we all want a fair price. There's no fair price, no set answer. And there's different prices for different people. If you're talking about the majority interest in a firm, that's one price. If you're talking about buying a minority interest, which means whatever corporate entity you have, the reality is you don't really have any control, no legal control. The guy with 51% technically can fill the board with his people and do whatever he damn well pleases with minority protections, fiduciary duties. But basically, where are you in hierarchy? Who's buying, who's selling? Because those are different prices for different people. You get a lot of this stuff. Back up a slight tide here. Figured out the other day some of my own shortcomings for doing the financial things. There's the old Maslow sort of thing that to a man with a hammer, every problem looks like a nail. And I've figured out I've got a companion for that. To the man without a hammer, no one gives a damn about a nail. It's, they don't care about those things. I don't have a hammer for financial stuff. They bore me. And so I don't value them heavily. And I look for chances when I can to disparage them because it makes me feel better about myself. That said, there are just a gaggle, as my term is not a bad one, for all these norms, industry norms to value a firm. And if you look at Zag White, they've got at least 4. And PSMJ has another 4. True story. The participants' names will be withheld for obvious reasons. But have a client that did a very careful transition and very well, did a great job of it, by the way. But basically, one of the big issues here was the principals who were leaving. What should they be paid? And the idea was to pay them over time, as you'd see how the practice evolved over time. So rather than just set a price on day one and then hope that met the future, there was a scheme to do different prices over a period of years. Clever scheme, nicely done. The CFO types put together a very careful Zag White blend of 4 different Zag White methodologies. So whichever one was a little out of focus, it would be a fair price at the end. So they could count on that. So that was a deal. And we launched it. And the first year hit it out of the ballpark. Great year. And we put all the numbers, they put all the numbers into their formulas. And the principal's price went down. Lost money when the business expanded. And they investigated and thought, well, actually, it turns out that year, the Zag White metrics were kind of off. The firm didn't have the same base it had before. So they put good numbers into bad metrics. And their solution was to go to PSMJ and get their 4 models. And so now we have an 8 model averaging to get a fair price. And to the CPAs of the world, it makes a lot of sense. To some of us,
that could be described as a little extreme.
Yeah. Well, but it shows my my reluctance to embrace the numerical approaches totally. And last thing I mentioned already, when you're doing a value, what you really want to do is predict the future. It's the price over time. What's this going to be worth after the transition? Well, sometimes it's hard to predict the future. So what we do is we look back and say, well, here was a track record and here was a book for, and this is what we did 3 years ago or something, which drive it in the rear view mirror, it doesn't make a lot of sense, except that's all you have. But a scheme that I've come to like is maybe we'll determine the price over a period of time. So if after the transition, the firm does well, everyone makes money. If after the transition, it doesn't do as well, at least the buyers want to overpay. But those are things I have in mind when you're trying to determine a value for a particular firm in a particular situation.
and on a, whether it's internal or external, there's, like, as Mike said, there's any number of ways to do it. There is no right or wrong. It's just, at some point, the principals just kind of sit down and say, I think this might work. And I'm more often than not seeing internal values versus external values when it goes out to a third party versus if they're trying to get an internal sale or some sort of internal succession plan going. Again, no right or wrong here, but I do, I have seen those. Those seem to be more common. All right. So if you're okay with value in the practice, the other thing that, and this speaks more on the third party sale, things that really speak to buyers include your future leadership. So those are going to be kind of your current principals. How long are they going to be working? Do they want to work post sale? How are they? What are their niches in the market? What kind of professional relationships do they have? So when buyers are looking at us to buy, they really are focusing on what is the current leadership. That being said, I have seen buyers walk when there's not a lot of bench strength. One of our clients calls this the number twos, and it's not just your number two. It maybe you may have 3 number twos, but they are looking, because a lot of buyers, especially the private equity, they don't necessarily know the business. They're going to infuse the company with some money, but they know that the current leadership is probably going to retire after 2 to 3 years, because that's a typical post-closing relationship with the current owners. But then they're going to say, and they may actually add additional value to the purchase price if your bench, your next generation, is really strong. So it is important, if you have not already thought about that, is how best to sell that. We'll get into that a little bit later. In addition, other things that make a practice more valuable, kind of like in real estate, location, location, location. In here, it may be your client base. The buyer may just want access to your client base. And I'm still of the belief in your market that professional relationships are key. So your key people, your current owners, but the ability to make those relationships, that can put a premium on your purchase price, as well as the market niche, because sometimes it's harder to get into the market. Again, I would go back to the professional relationships. But that when you're unloading, at least on an external sale, the buyer is more likely to perhaps add a premium to the value because of those two things. In addition, a buyer, and I've seen this, whether it's private equity or you're just going to be joining either an architectural firm or an AE firm or a DB firm, whatever, they are looking for consistency. What is your financial, how have you been doing over the past 3 to 5 years? What have you been revenues? What are your expenses? Have you grown? Have you retracted? And things that wouldn't otherwise be explained. So, they would have tossed out 2008 to 2010 because everybody was suffering from the recession. But other than that, they want to see in a normal market, well, how have you been doing financially? Are you about the same? Or do you do this? And if you do this, well, maybe you're not going to get as high a value on your practice. And then finally, and this probably the last two are probably a function in and of, they kind of function together. I think that some of the best companies run well and have consistent track records because they have really good business practices. They have really good systems in place. Somebody every month is watching the recorded hours, the expenses, the projects, the backlog. Are your projects on budget? Are you over budget? Are we making sure we're getting things done? Are we paying our bills on time? Those sorts of things. So that those systems, quality control manuals. A lot of really good companies have quality control manuals. So they want to see that those have been instituted and will run regardless of even the future leadership. They are in place. I've seen the value of a practice be, again, awarded a premium for that or been more highly sought after just because they're not something that's cobbled together. They truly are a running business operation, an ongoing, what I would call an ongoing concern, a well-run ongoing concern. Did you want to add something?
Yeah, let me do a couple things on the business practices. One thing I think I mentioned, I'm not real wild about financial management and all the numbers and spreadsheets and stuff. Generally true, but I've been very impressed with how other people are impressed with that. So for internal sale, it doesn't matter so much. People know the firm and their business and they're comfortable with it. For an external sale, especially when financial types come in or venture capitalists are coming in to put cobble firms together, do a business deal, those financial controls are very valuable, very, very highly regarded. And maybe not so much in the positive, but it sure lets the air out of the balloon when they find that the people running the firm really don't know how the numbers have worked for years. And they kind of put themselves in a lower category of just, maybe we'll help these clowns out, but you lose a lot of respect in the financial community if you don't understand financials.
Well, I think what they also think is that you don't even understand why your business is growing or shrinking. It shows just kind of either a lack of complete understanding of what's going on with your money, both on the service side, both on the expenses side. How you don't particularly understand how to write your proposals, where you could be losing money, where you could be making up money. So for the business types, the underwriters, if you're going to finance, it is very important to have those financial controls in place, or at least be working towards something that is better, so that if you're asked questions as to, hey, why the dip here, you can answer that question. I would like to say about the key valuation factors, this is what we've seen. This is what commonly comes up. These 5, these are not exclusive. There are other things that might add to the value of a practice, but from my perspective and my experience, whether it's an out-of-state buyer, an out-of-country buyer coming in and buying your company, this has been their focus. These are the most common factors that are requested, asked about, pushed, values gone up or down on the purchase price.
Yeah. Just a couple other thoughts on this. Observation for me, I don't have the expertise to know that this is true. My practice has involved me a lot in looking at understanding firms' practices, their actual architectural practices, not so much on their financial controls. But I have noticed over time that there seems to be a correlation between firms that are doing better design work and firms that are better managed. So I don't know if that's just something I've, an artifact or made it up, but I've been impressed more than once that when you get to a firm that's got nice, well-running practices in their practice act, the finances seem to follow. There seems to be a correlation between running the business well and the practice well. The other thing, regulatory compliance. No one likes this. But just a couple of observations here to put in here. There are a lot of regulations for businesses. Not a political bent here, but it's everywhere and everything. And so, frankly, part of what I've seen is, well, I think Michelle had a situation recently. When you do work in other states, they all have their own practice acts. And there's just a minefield of all special rules and stuff. And when you're going to sell a firm, again, third-party sales, so people look at it, there's going to be due diligence, and they're going to see that you're running your practice right. And there could be some very embarrassing moments when you find that the people who are running the firm didn't understand that Illinois has a different practice act than California, or didn't bother to register, or aren't complying with practice acts in those states, which also threatens your license here, by the way, because they all talk to each other. But in any event, good idea to keep that in line here. But there's another thing. So there's another life of employment lawyer, actually in this life, because that's just the norm. Every firm that I know of has a risk of wage and hour problems in California. Every firm. I don't know anybody that does it all right. And again, if you don't get caught and life's going on, it's probably not even totally possible to comply with all those things. But again, if it's a third-party sale and there's due diligence, and you find you got a minefield there of non-compliance, which is penalized and taxed, et cetera, you might find the value of your firm, again, the air comes out of the balloon, when it turns out you've got problems you didn't even know about. Your buyer finds them for you. So comply with those things as best you can.
Yes. Okay. But before we jump onto the next slide, to jump on that, I'm doing a sale right now and we're in Florida. And I was talking to Florida counsel today and he said to me, wage and hour trolls are on parole and they've hit the AE market there. Well, I think we've lived with that here, but just to put a fine point on it, it happens. It may hit us first, but it also hits other states. So if you're practicing it, I will get into real specifics into that later with the regulatory compliance, but as it concerns an external sale, but it really does come up. It came up this morning. All right, you're up.
Okay, now we're going to talk about internal, external transitions, internal transitions here. Let me start some basic things here. Again, as with the valuations, there is no legally prescribed process. None. So how is it done? How's it supposed to be done legally? What's the custom and practice that gets incorporated into legal obligations? No answers. Sorry, don't have it. Every firm has to find its own way. Every firm has to invent its process. So sorry, be nice if I could tell you this is how we do it, but there is no way we do it. There's a natural dynamics though, and just my personal experience. I kind of ran into this problem early 90s, as that's when a time when the economy took such a bad hit that any deal that had been done in the 80s was dead by 91. So just a lot of blood on the floor, a lot of hassles. So fun time for a lawyer to come in and learn about that. And in working through that, I invented a very clever 3-phase process for how we would do this. And I tried it and it worked. And I feel it pretty good. Then I came to realize, as I dealt with more people, anybody invented the same damn practice. It's nothing unique or brilliant with me. There's just a natural dynamic that kind of directs these things. So we're going to talk about a 3-phase process for how you bring in people and handle the price and the buyout sort of stuff. But there is general ways that this is done, not because everyone writes it down. It's everyone kind of finds their own path, and it's the same path because it's the same people problems. So there is that to be had for it. And then likewise, timing, there's no answer to that. Although I will put this part on it. I have had, well, we both had more than enough times when somebody comes in and says they want to get out next week, next
6
year.
months.
Yeah, I can stay a year. Can you work with that? No, actually, no. Well, we might do a third party's fire sale, but basically these things take time. And so if you're not getting ahead of the curve, planning early on, you can run out of time real fast, and no one will tell you what the deadlines are until you've crossed them.
And it's also important to understand that you can be looking at your exit plans, what your succession planning, what people call them different things. You don't have to go one way or the other. I know lots of people that are looking to sell to a third party, but are also trying to do a succession plan. So I don't think they're mutually exclusive. I don't think you have to go down this path, but so keep that in mind. Yes, you can come up with these internal succession plans. Again, we were talking about what makes your firm more valuable, but even though you're doing that, you may still want to sell to a third party, and keep that in mind and keep your options open. Either way, it takes a lot of time.
Yeah.
Planning.
Now, the brilliant thing, can you explain
The
that?
people dynamics. Okay. Well, I apologize if there's any millennials in the office or in the on the show, because not all of you are like this, but finding people and developing the successors has been a challenge. And I don't think it's just in the AE. I think we find in the legal community. I know I talk to accountants and we're all finding that. But finding people who can take over the business, or two people that can take over the business, is huge and key. And I have seen and been a witness to identifying one or two candidates, spending 2 or 3 years developing them, and then they leave. Not because you did anything wrong, they just, whatever. I mean, everybody knows in the pandemic, a lot of people just like took off and moved. We found out later, but really identifying people who you think are good, have good abilities as just business types, right? They have the ability to get the work done. We have our 5-step plan, but they'll get the work done. They can bring the work in. And then they can manage not only their workload, but other people, and finding, sometimes it's 1 or 2 or maybe 3 people who can do those 3 things. And so for us, finding that at least those 3 categories can be difficult, time consuming. And then there's the concern that, they may, you may train them and then they leave. I think that's always a risk. The other thing, and again, I don't know if it's in this generation. Maybe they thought about this because I'm Generation X. They thought the same thing in my generation. Finding someone with an entrepreneurial spirit, or I would call them risk takers, is getting more difficult. The ability to want to come in with money, to invest in something that may or may not produce in the future, it just seems to be more difficult. And that's just what I've been hearing from other people. So finding that, if you can get your hands around somebody who is more of a risk taker, I think that's good, especially since I find small businesses in the United States generally are run by people who just have an entrepreneurial spirit. I think most of you, because I've seen some of the names, I know who you are and what you do, and you all have the ability to assess and are okay with certain risks. And I think finding someone to take over and understand that's a key component in finding a person to take over the firm. And then compatibility. I mentioned it a little bit. They manage people, but they're also compatible. And I mean this sincerely, not just with you. I mean, they're compatible with the other principals, that they're compatible with the staff, that they're compatible with the type of work. Because at some point you're supposed to transition out, or the group of you are supposed to transition out, and leaving that next layer. We'll get into letting it go later, but finding someone who's compatible with the people, the spirit of the firm, the collegiality of the firm, whatever your firm culture is a really important identification component when you're identifying people.
Let me expand upon this abilities part of this. Most of it, I think I have a metaphor, and mine here is question: what's the most important organ of the body? I mean, the heart, the lungs, the brain. And the truth is, if you don't have several, you don't have anything. And so I'm looking at firms that way as well. When you're trying to develop the people who can actually take over the practice and buy you out, you need different roles filled. You need rainmakers. Somebody has to develop the work, and that's not always easy, and it takes time and some experience and maybe some gray hairs. But if you don't have that, it won't work. You need producers. You need somebody that can get the stuff out, and quality work that you can sell or whatever. And that's usually different talents. Different personality types than the salespeople. And the most difficult part to fill is somebody has got to run the business. You need the CFO types. And if you don't have it, it's not going to work. My personal experience, I took my own little MBA course 20 years ago now, and hired a series of MBAs to run my practice. And I just recommend against that anyone even trying it. And I'll tell you one thing, no one spends your money like you do. So you need people with skin in the game, people in the firm who have business management inclinations, which is not what you learn in architect school. But if you don't have them, you're not going to get this thing into a viable transition. So you look at those things.
I would add one other thing to this. It's if you have one candidate that you're going to transition to, that is perhaps could be easier as a pass down, like when you're handing the torch down. When you're going to, or you're thinking about, and maybe you've identified 2 to 3 candidates, making sure that they're compatible and they work well with one another, because there's, generally speaking, when you find people who have an entrepreneurial spirit and they produce and they manage, they're pretty ambitious, right? So managing that inter-competitiveness, I think is something that is sometimes forgotten and could torpedo certain internal transition plans. So I raise it, not that you have a problem with it, but that I've seen it. And then they don't necessarily get along, then the people aren't getting along. So I think that's part of the senior group, the owners are trying to get out, is really trying to foster that next level and make sure that group is collegial with one another. And everybody either as Mike was saying, they kind of find their roles, or so that there's not some inner fighting, I should say. Very important, because that can torpedo a plan. All right, so once we've identified our people, 1, 2, 3, 5, whatever it is, typically where we're asked to come in is, hey, what does it look like when they come in? And again, if you've got the entrepreneurial type, or it's at the right point in their life, finding them to come in and buy into the ownership becomes the next level. We'll talk about how that's done in the next slide. But how do we typically attract a potential next generation owner? So you could provide them equity, right? They're going to be an owner of the company. Now, if you're an architect, sometimes you don't, they may not yet be licensed. So you don't want to bring them in yet. But if you are ready to make them an owner, then as we talked about valuing the company, that's going to be a real part of the next discussion, which is, hey, I'd like you to become 2% owner. And then you say, here's how much it's going to buy, here's how much it's going to cost. When we do internal transitions, we always say, bring them in slowly and give them something that's really friendly credit to them. Because typically when you're bringing people in to the next generation, they may have families, they could have debts, they could have cash crunches that they don't even want to tell you about. So making it as, I should say, financially friendly to them, something they can absorb as part of their expenses, their monthly nut every month is probably the single number one thing that becomes a problem in these transitions. They just can't afford it. There are other ways around this. You can offer profit sharing, which is more of a contract, which says if they help grow certain things. We use stock options where we set the stock low, and then if the company grows and hits, or we sell, there's all sorts of ways to do it. Then they can partake in that profit distribution because they helped accelerate and grow the firm to be more profitable. So, and a lot of times the nice thing about stock options, they don't have to come out of pocket. It's there, it's just sitting there. So there is definitely that. Before I get into the commitment, do you want to talk about?
Yeah, and the other thing we do is kind of sometimes you sales over time, kind of they start buying in. So installment sale approach. The key to that, I think, and it's not a bad idea to have a good tax savvy CPA involved in here, or consultant type. There's a lot of ways to do this. And it don't always, sometimes you want money, but we can work around that. You don't need a lot of money to do this, at least up front. But here's the other side of it. 2 things. I have seen twice, both against my advice, firms give equity. And both times it was a disaster. And I think it's just a people sort of thing. When you get it for free, you don't value it. You got to have some skin in the game. You have so setting the price favorable, easy credit terms, good idea. Giving it away, it does not work. I have no legal basis for that, but I've seen it. Very bad idea to do it for free. There's another aspect of why we highly recommend that at early stages, people get some equity. There is a wild difference in mentality between an employee and an owner. Again, I have no legal authority for that, but I've seen it and I've lived it. It's different. And so having someone make the transition from an employee, what are you going to do for me, et cetera, to an owner, it's my shop, I'm trying to do this, takes time. And it doesn't always work. We've had a number of cases where you give a little equity and people now have a new status, new position, a new power in the company, and they become nasty and they become demeaning to other people, and they start taking time off because they're a partner now, or they rise above it and they actually start embracing an employer's mentality. And I don't know how to predict which is which. I've predicted it often. I'm usually wrong, but in any event, you want some equity because you're developing the mentality, the attitudes of these people. So you need something in there to start that transition. And they need to pay something for it. It shouldn't be free. After that, we can talk. A lot of ways to maneuver.
A lot of times if people are not yet ready to sell or buy into the company, a lot of times what I'm starting to see is that they'll bring them in into more, let's say, more confidential or more sensitive discussions. So they might be brought into a profit and loss discussion on just the books. They might be brought in, introduced to some management. They might be asked to assist on the AR. They might be asked to learn the contracting. And that way the owner or owners or principals can see, well, how do they act? How are they doing? We're giving them some more responsibility, right? Before actually offering either a sale. You can do it at the same time too, but I can't, again, once I think someone becomes an owner or thinks that they have owner status, to watch, because you have to be able to get rid of that. That can squelch firm culture overnight. But generally, going back, if you're going to do an internal transition, the actual sale of shares or partnership is done. That's going to be a purchase price that's going to have payment schedules, which we would say would be friendly and over time. And then if you're not interested or not yet ready to offer ownership, but most owners are because they want to get out from underneath being an owner, might do stock options, profit share, those sorts of things where the next generation isn't yet an owner, but we're trying it out. We're trying to see if they'll buy into that. And sometimes they'll do that for a few years and then they'll turn that into equity. Those are typical in your business. As Mike said, skin in the game is big. That you get them if they understand that they're putting real money in. Typically, they're more invested. That's the emotional part of it. When they're part of the finances now, they're part of the in group. That's an emotional commitment, and which can be great. And then legally, that's where the lawyers come in. We put together documents. So it might be a stock purchase agreement. It might be a profit share agreement. If you're going to make them an owner, it's definitely going to be a shareholder agreement. And a lot of employers or a lot of companies, AE companies, will do principal employment agreements. They're not absolutely necessary, but sometimes they do, because when they're making or bringing someone up, they want to give some additional benefits. Looks cool. It's a term. Instead of an at-will employment, it might be more of a term. And again, that shows the next generation that, hey, we really are invested in you. Look, we're gonna make this for a period of years. We're going to give you some extra benefits, and then they feel like they've earned it, right? It's about that. And then before I know you're going to jump back in here, the most important thing we do when we're counseling here is to make sure that we can unwind the deal if it doesn't work out. Most of the time they unwind themselves. We don't have to get involved, but maintaining that control, because you, like Mike said, we don't know how the successive owners are going to act in their new position. So until we're comfortable, we bring them in slow and have the ability to pull it out, pull the power. I should pull the ownership.
Yeah. Abort. Let me just tie in here the emotional, legal, one maybe third tier point, but something I've come to believe is pretty important. When someone starts in the process, we're going to make them a major commitment. And here's a career path that it's going to work for both of us for our careers. It's a hugely important decision. So we also want to get some reciprocal commitment. They shouldn't just be able to come in, flirt out. So the shareholders agreement does some of these things, and too much detail for now. The principal agreement, one aspect of this that I highly recommend is it's not at will, it's for a term. And I have no legal authority for this, but the term is 3 years. And my thinking is that everybody has the bad Monday morning when they decide to screw it, this is not what I had in mind, or too much, I just want out. It's the lock that keeps an honest man honest. So people will stay there long enough to see that this works and melts and gets going. If you always have the ability to terminate for cause or whatever, it's not working, you can always mutually agree to take separate terms. But I really like the legal commitment to have an emotional hold that you're going to be here for a period of time at least, and give it a fair shot. And then you commit that to us, we commit this to you, and I've seen.
Hopefully it works.
Well, I've seen two things. I had, we had one client where one of the guys was kind of reluctant, and I talked to him personally, and I understand that, but without 3 years, it's not fair. I mean, everyone's committed to the same sort of deal. So realistically, you shouldn't come into this thing if you really don't think you can commit to 3 years. And he did. And at the end of 3 years, he left. I kept it as part of the bargain. That was fine. No hard feelings, but it didn't work out. I've seen other clients where I'll set this 3-year thing in motion and come back 4 years later and no one even knew the time expired. No one paid attention to the agreements. Didn't come up. So either one is fine, but I do recommend having that 3-year commitment.
Yes, and a note on profit shares, whether it's tied to profit sharing and phantom stock, but mostly the profit share, which is kind of tied to a future event. They will do things once they are fully vested. So let's back up. Sometimes people will get like stock options, some sort of a profit share where they vest in the ability to get paid out or get some sort of return on growing the company that vests over time. And Mike was saying 3 years. I've seen it 5 years, but I have seen it where they will grow for 5 years, but immediately upon that full vesting, they tender the termination and get paid out. So you may think it's going to work. It's out there. It's a risk. I wouldn't say not to do it, but just note that they know their vesting schedules very well, and we'll watch it. Okay, let's go to the next one. So assuming you've sold it to the owners, the succession owners, and you're doing great, you're probably like, well, wait a minute, how am I supposed to protect myself? We talked a little bit about, abort buttons, the termination for cause, the right to terminate, let me back up. But there are other things that you could do to make sure that even if you're bringing in several people, they have control, but they don't they don't really have control of the company. So when you bring people in, you might bring them in as a 2% or a 1% owner, but as part of their documentation that they agree that basically you are on the board, or the 5 of you are on the board of directors until you've sold all your shares. We sometimes call that a shareholder voting agreement. It's typical in the shareholder agreement, especially with founding shareholders. And basically you say, look, the founding shareholders are going to be a member of the board. We have some clients who, if it's working, and that, let's say you've got 5 members of a board and you've got 5 new I'll call them the next generation owners, at some point they will add 1 or 2 to the board. So they'll make their board not 5, but 7. And then they will add 2 of the next generation owners to the board, and they will rotate those new owners over every couple of years, maybe 1 or 2 years. You sit on the board for 1 or 2 years and then you rotate off. So there are ways that all the founding shareholders are still in control of the company through the board of directors, but you're training, I'll call it training, you're training the next generation on the business of the firm. Other things you would do is you would do stock pledge agreements. So that's basically if they don't pay for their stock, they have to give it back. How we want to deal with the payment of notes, I'll be honest, for internal transition, it's unusual for in an internal transition to have a lot of security. If you are truly, if the new generation is coming in and buying out a major shareholder, yes, there is more discussion about how to securitize that note, but it's nothing like a bank. Because that can interfere with all sorts of things, your lines of credits, leases, other financial documents, SBA documents, other loan documents. So if you're thinking about selling a huge chunk, the security might be more of an issue, but just know that it's a talking point. And then I see veto rights not in when we're doing baby steps for the next generation. So if I'm bringing in 5 new shareholders at 2%, well, that's 10% of the company. They don't have a lot of control. However, last year I did a transaction where the 5 shareholders sold all their shares to 2 owners. And we went over and over again about how they were going to pay over time. But one of the things that the departing shareholders wanted in the shareholder agreement were veto rights, right? You've now left the firm, right? All 5 of them are leaving the firm, but they have a purchase price that they want to get bought out on. And so part of their negotiation was to make sure that in certain circumstances, they still had veto rights over the business, especially if they saw the financials starting to collapse. So to protect yourself, yes, if you're going to sell all of it, if you're giving up majority control, then yes, there are certain things you probably want to protect yourself in that documentation. And one of them is a veto right. So
let me do another aspect of the control sort of thing. Doesn't fit exactly into this scheme, but another aspect of it to consider. You want people to be committed. You want to be able to keep them there, but you want to have control of the company. But then they can always leave because of that 13th Amendment sort of thing. So there's a balance. A couple things that are done. I don't know that I have recommendations on this, but there are a couple things that are done in order to keep the transitioning people from bolting early or revolting. One of them is the ever popular covenant not to compete. And that's well misunderstood in California. But you could have covenants in agreement when somebody sells their interest in a firm that they won't compete with that firm for a year or 3 or 5, or in this area or that area. Could be pretty nasty, can be pretty controlling. In some states, they're vicious. Just had a matter in Ohio where pretty draconian rules. In California, it's exactly the opposite. Courts are very hostile to covenants not to compete. So people say, I'll do a covenant not to compete and lock the son of a bitch up for a while. Well, maybe not. Yeah. So it's got to be very limited. And we've got one that would be enforceable, but it's also got some limitations on it because otherwise you lose the whole thing. So it's not what you hear about it, but it's not what you might think it is in California. If you're dealing with employers elsewhere and other state laws apply, it could be huge. The second thing you do, and this I do recommend, this is part of it, in a shareholders agreement. You always have provisions that when people leave the firm, they automatically sell their stock back. At what price? And typically there's a formula or whatever, so that when they leave, they get 100,000 or whatever. There's also provisions that are quite enforceable. And again, this is something I recommend kind of draconianly, is that your value of the stock is in large part goodwill. And as owners, they were vested with some of the goodwill of the company. And when they leave, some of the goodwill of the company, some of the value of the company leaves with them. So guess what? The stock price goes down. You have a different formula. So for people who are leaving to compete with the firm. So those are things that, again, we're getting some fine points here, but those things can be done
to help protect, to protect against a next generation owner who leaves early.
Yeah, exactly.
Right. Before you've completed the transition. And then a note before we go to the last slide, which is going to answer the question on the board. If you've decided to start transitioning out, I think some of the transitions that I have seen that have also failed isn't because the next generation didn't want to take over, but that the old generation didn't want to leave. And in a sense, giving the next generation owners a paper tiger position. So I think once you've made that commitment, standing behind your next generation owners, obviously assuming that, that they're not being, too authoritarian or, something that is hurting the firm culture, getting out of the way to the extent you can, really backing them up, really being, I would call it the adult in the room, so that you can basically let the kids fight it out in the sandbox, but also grow into teenagers and adults. And then you can step back. But if you don't make that commitment to transition out, I think you can stymie the internal transition.
You talking to me?
No.
No.
Okay. This is you.
Yeah. General sort of problems I've seen, pitfalls that we have here. I'm not speaking about me or my family. I'm talking generally here. You always have to know who you're negotiating with. And it's usually not the person you're talking to. It's usually the significant other. Because whoever you're talking to, here's the deal, here's the risk, here's the money, here it goes. They got to sell it at home. So a mistake I made earlier, haven't made it for a decade or so. Yeah.
Okay.
No, it's got to, you're really negotiating with the family and the significant other. And if you understand that, you can get some people to say all the right things now, but you're not getting the deal. So just accept that. That's part of it. Changes. I'll get back to, I mentioned before, a lot of blood on the floor in the early 90s because no deal made in the 80s could survive. It was financially viable when the market dropped in half. And so one thing people could do is adapt to reality and change. Another thing people could do is say, read your damn contract, you signed it, which is legally correct, but kind of stupid. So I've seen a certain amount of ill will and problems and what should be happy retirement's tainted because of disputes at the end where the deal was fair when we made it, but things changed. And so it's not so fair anymore. And so somebody now feels they're being disadvantaged or taken advantage of. And that's not a good way to end your transition out of your firm here. Taxes can kill these things. They can be high. And so you need tax effective schemes, and they need to be understood, because people get blindsided by tax liabilities, and that's a real problem. So tax plan. Everything we do, my metaphor here is kind of between an architect and a structural engineer. We like to play with doing the great program in the building sort of stuff. Someone has to make sure it stands up. Someone has to do the structural planning. Someone has to do the tax planning, because the tax structure is key. So you need to have it, and you need to understand it. People have to buy into it. And if you don't do it now, when it comes up later, that can be a huge pitfall.
Before you go on, hold on.
Yeah.
So when you're doing your valuation, whether it's going to be an internal, you're going to just do it, you're going to sit down with your either accountant or whoever you're hiring to do your valuation. I think before you present your plan to your potential next generation owners, that this tax plan, that's what's going to, what Mike is saying, you really have to understand what the effect is going to be to you, because you don't want to try to sell a plan and then try to unwind it because, oh, it's not advantageous to you. So just understand that when you're going out and you're trying to put a value on the firm, and you're trying to come up with, hey, how do I do this over time so that A, it's friendly to them, and two, I'm not going to get killed in taxes. That happens before you even sit down with your group of next generation owners. That was what I wanted to say about that.
Okay. Fiduciary duties, other side of the coin. We talked a moment ago about the sellers, the founders, keeping control. And there's a lot of ways to do that. And that is actually done, and a mistake not to do that. But you have to understand that there's a different relationship between a founder and an employee, even a key employee, and a founder and another partner. And there are fiduciary obligations to minority shareholders. And so even though the founders might be in a very solid technical legal position to dictate terms of changes, you got to temper that. You have to understand that there's obligations to be fair with your minority shareholders. And if you think just reading the shareholder agreement, everything there is to read about it, you miss the point. It overlies all that. So there's some reason to be kind and generous, even if you don't feel that way, because it's not as nearly as clear cut as you'd think by reading the legal documents. Okay.
And then the ESOP.
Yeah, just a fast thing on ESOP. You hear a lot about these things. And I've seen a couple of them, and I'm actually kind of working on one now, or working on one now. And I'll just say this: there can be a real, here. What is an ESOP? This is a plan, a tax efficient plan, where the founders can sell a certain amount of their stock. 30% of the minimum to start. You sell 30% of your equity to a trust that's set up that then gives ownership to employees. So various employees can become owners through an ESOP, and then there's real tax advantages to the founders for that 30%. So that's why you do it. So it's there to encourage founders to be generous and spread equity in companies, because that's just a policy. Someone thought it's a good idea, or maybe someone wanted the tax benefits and had the right financial articulateness to get those things passed. They are, I think, of limited use. A couple things. If you want to do an ESOP, you need to be a C corp. And sometimes, which you can change, but I mean that's that's a step that causes it. You need a lot of advisors. And
Especially ERISA advisors.
or highly specialized area, read high hourly fees for both the attorneys who actually put this up and then the accountants and whatever who do this and vet it and lay it out. It takes months. I think the fastest track I could get for what I'm talking about now is we might do this in 3 or 4 months, maybe 5. You're shooting for the end of the year, and you can't just file some paperwork in your ESOP. There's a lot involved in the
Oh yeah,
process.
there's a lot of regulatory things involved in it.
Very expensive, and then it has to be the expenses occur every year. So unless you're talking about a pretty substantial company, it's probably you might flirt with it. I can refer anybody to I think a very good ESOP advisor who he's honest enough to let me know I was taking the client on the wrong place, so at his expense. So we can do that. But you hear a lot more about it than you see. They're actually kind of rare. They don't work in a lot of situations, and they're very expensive and entangling. So. And
they can be well, and then when they don't work, the one I was really involved in had to be unwound, and they required personal guarantees. It was a mess. I mean, he got out from underneath it, but so it's not to, as you can see, it's not our favorite thing. But if we have good advisors that will tell you if it's good for you. So I have one client who's going to use one. So that's their plan. Okay. All right. My favorite topic is the external sale, because I do this like every day. My goal here is to give you a 30,000-foot overview of the life cycle of an M&A. This is a third-party external transaction, which can be, if I would be lying to you if I said it lasted anything less than, I mean, it just takes a while. You've got to ramp up, you've got to date, you've got to get your LOI, and you've got to get everything across the goal line. I love it. I have been involved in a ton of transactions. I work with a lot of the same people, a lot of the same team members. And it can be a fun but very exhausting trip for people. So this is an attempt to try to tell you, if you're going down this road here, in my opinion, this is how it works. And then maybe best ways of trying to avoid some pitfalls that I see, especially in the AE side. So the general process is, if you are, and remember, I told you could do the internal succession along with the external succession. But if you're really thinking about selling to a third party, making sure your team of advisors is assembled is really important, and getting the right consulting accountants and getting the right broker if you want to go the broker route. And I do. The AE market is really popular right now. And there's a lot of private equity, and there's a lot of international as well as national interest in California. They're gobbling up firms. So, and I've just done a ton of them. And I think also the reason it's hot too is because there's a lot of COVID fatigue on some of the owners. They just got out of the 2008 recession, the Great Recession, and then they got hit with COVID. So they're like, I'm done. Anyway, I think it's a really hot market. So getting your team together, then there's the process of getting the company ready for sale. It's kind of like getting your home ready to be put on the market. It's a different process, but it's the same idea. You're fixing things or making them look pretty. The third thing is then, once you put the company out for sale, reviewing and analyzing and courting the buyer, having the buyer court you is really important. I call that the hair on the back of the neck test, followed by, if we're happy and we want to continue dating, we get an LOI, we go through a period of due diligence. People don't understand that that's different than the next phase, which is preparing all the documentation. And then finally, assuming you don't have transaction fatigue, everybody closes and has a great big party. So that's the life cycle of a mergers and acquisition. I have a lot of people can get stuck in 2 and 3 for a long time, but it's nothing that happens overnight. And I'm sorry, and it typically lasts anywhere from 3 months to, it can be a couple years. And sometimes you go through several buyers before you find the right fit. Okay, so assembling your team. Who do we think the best teams are? The team are obviously the affected principals, right? And for those companies who have, you know, more than 2 or 3 principals, typically what they'll do is they will say, hey, we're going to make, you know, Joe the head of they're going to basically take the lead on the negotiations. I have that now where they basically said, hey, you take the lead. And then he goes back and advises the rest of the team. Doesn't mean that, you know, you're not involved, that the entire team doesn't get together, but you have a key player. Then there's obviously the attorney. You need somebody who's experienced in the M&A field. Number 3, I think it's incredibly important to have a really good, and I'm not talking about a CPA type that just does your taxes. I'm talking about the consulting architect that has done these types of deals, understands stock transactions with 338 elections, F reorgs, which are kind of the new thing in our field. They've been around for years, but understanding asset sales and the taxation, the different taxes is huge in the analysis. Then if you really want to sell, you have to have a specialty business broker that understands the market, where the buyers are, where the sellers are, has the ins, has the ability to make connections, is fluid in that space. And we have a couple that we work with all the time. There's some local, there's some international and national, but that's a really important team member. And then the insurance broker, we'll talk about how important they become when we're trying to protect that tail. And then the benefits advisors, they come in more on the transition, especially if we're trying to protect and transition appropriate benefits from the old company into the buying company. So those are the 6 key players in our mind. I work day to day on my deals with the first 4. The insurance broker and the benefits advisors come in, but it is really important that your broker is involved early so that we can understand what we're going to do there. Okay, preparing the company for the sale. I think sometimes people forget this step. They want to go and they figure, oh, I'm going to hire a broker. I've got my team. I'm just going to say here. Well, it isn't. It would be like putting your house up for sale and not fixing the leak in the roof. You're just not going to get the valuation. You're not going to get the offers that you think you deserve, and you do deserve it. But if you properly prepare, you have certain things in order when you go to sell. You look like a well-oiled machine. You just do. You look professional. We were talking about buyers like people that look like they've got everything together. Well, this is part of it. So what are the things that we do? One is making sure your company books are up to snuff. I cannot begin to tell you how many times I've gone to do a stock sale and the ledger has never been done. The stock certificates are scattered. Nobody really knows. And we have to put that title together. We have to check to make sure you've done the annual minutes. We want to make sure you've got personnel manuals and all the things that the company should have already done. It has to be brought up to date, because I'll tell you, once you get past where they're asking actually questions about company documents, you want to be able to fire those up and you want to be able to give them away, and they need to be up to date. You need to look good. You need to look like you know what you're doing. So that company books is more from a legal, kind of a regulatory personnel employment manual sort of thing. Then the CPA, your financials need to be in order. Understanding your balance sheet, your profit and loss, where your WIP is, where your AR is. I have done deals where the principals could not answer basic questions about their profit and loss, their balance sheet, or their balance sheet. They just did not know what the numbers meant. And I think that reflects poorly on the sale process, because the buyer may have specific questions and or want answers so that they are not scared away from certain, let's say debts on your books, or projects that might be upside down. Which brings me to the third one. I actually have been through deals where companies have projects, but they are not tracking backlog. What do I mean by backlog? Some people call them works in progress, but basically it is a list of each project, whether you've got consultants, your proposal, your budget, where you are in the project, how much you billed, how much you're owed, how much is left. Because part of the valuation may also be subject to how much backlog they see. Are you signing up $3-5 million contracts? So there's going to be, $15 million worth of backlog in the future. So, and so having that go-to place, backlog, sometimes it doesn't really belong on the backlog, but they'll also put like proposals in play. But that go-to sheet that says it's exactly what I'm working on. This is where my efficiency, they can see your efficiencies or inefficiencies. That is huge to have an understanding and a working knowledge and the ability to update it like on a 30-day basis. That's typically what the buyers will want. They'll want it updated about every 30 days. We talked a lot about the valuation. I'm not going to, talk about that here other than to say, if it hasn't been done, this is when we have it done. And we want, and we just want to make sure we're okay with it, that if somebody came back with that offer, we would be happy with it. Then I'm going to mention one other thing. Mike touched on it earlier. Most of the firms I know are no longer just practicing in California. Many of them touch other states. They will touch, the closest ones, or they'll touch other countries. And a lot of owners either don't get advice, they don't hear it, they don't understand it. But let me make it very clear, in your space, every state needs to be looked at. If you're doing business in Nevada, whether or not only the individual architect or engineer needs to be licensed to practice law there, but also whether or not this particular jurisdiction regulates or requires a firm registration with the Board of Architecture or the Board of Engineering. Every state that you go into, you should always be registering with the Secretary of State. But I just did a deal, it closed. They did great work, but they were all over the United States, and we did 35 registrations in a period of like a month because he had just was unaware that he needed to know. It wasn't that he wasn't licensed to practice there, but the company wasn't. And one of the reps and warranties that you will make if you sell to a third party is that you are licensed, actually all your contracts say this too, that you are properly licensed to do business in the jurisdiction. And a lot of people think, oh, Joe Smith, he's licensed to practice law or practice architecture in Nevada. Well, that's great, but the company isn't. So that regulatory compliance piece, it's becoming a bigger issue. So I just bring it up here, but it needs to be addressed. Did you want to add anything here before I move on?
No,
okay. Okay, so once we have the team, we have our books, we look awesome, we are ready to go to market. This is where I think the broker takes more of a lead here, especially if you have and a good broker is going to be able to lead you through this a little bit. But this process is the courting. I call it the courting period. The buyer's going to go out and he's going to try to find. The broker's going to go out and try to find you guys a buyer. It could be a private equity buyer. It could be like I said, it could be a design builder. It could be another architectural firm. But it's his job as a broker to go out and find potential suitors for you. During that process, you may have a marketing brochure, kind of like you might have for your house, but for your company. But before you start talking to any potential buyers, you are going to want to have in place an NDA is a non-disclosure agreement or a confidentiality agreement. And this makes it very clear that anything that is discussed during this transaction, that you won't go around them, they won't go around you, they will keep it confidential. Why is that important to you? Well, How many people want to have it out on the market that they're being sold, they're looking to sell? They may not get contracts, they could lose people, their people can freak out, that happens a lot. And so it's very, very important that that is done with a third party. Little bit of a side note. When you are doing this, keeping the confidentiality of it among the company is a big deal. A lot of times our first meetings will be who's in the know, who knows this, how do we send bills, how do we get information? Because again, like we don't want the street, the market to know that we're going out to bid. We may also not want our internal people knowing because they may split. And that's not a good thing. So we get the NDA, we get some suitors. If a buyer is interested, generally they will give you a letter of intent. It's also called a memorandum of understanding, but it's generally a letter of intent. The letter of intent covers big ticket items. Here's my biggest four here. The structure of the sale. How are they going to purchase? They're going to purchase assets or stocks. We'll get to that in a moment. The tax structure or tax efficiency of the sale. Whether or not you're selling goodwill and how that will be taxed. And if it's an asset sale, how we're going to allocate value to the assets. That's a big deal from a tax perspective. The other thing that a letter of intent will talk about will be purchase price, how we're going to get paid, how we're going to treat our employees, how we're going to deal with professional liability insurance, who's going to get what kind of salaries or might the executives get big post-closing. So a letter of intent is like the bare bones skeleton framework of a deal. The things that I'm mentioning here, the structure, the tax efficiency, the sale of the personal goodwill, the asset allocation, these are the last couple of deals that went south were because the accountants weren't brought in and it wasn't fully vetted. And then once the letter of intent, it looked good on paper, but once it was signed and it went to the advisors, it got torn apart and the deal fell apart. So my view on the letter of intent is fully understanding a purchase price is great. That's great. But what does that mean from a tax perspective? If I'm going to sell an asset sale and I'm a seller, that's have a completely different tax effect on me versus the sale of stock, which typically is more advantageous for a seller. How are they going to treat my goodwill? If we're going to do an asset sale, how's it going to be allocated so that I may have to pay lower or higher taxes because of that? I just pointed out the skeleton of the deal is the LOI. This to me is the first date. This is the one that for me, the letter of intent can have a lot of good things, but I also watch how the buyer treats the sellers and vice versa. How does the seller treat the buyers? Is this a relationship? Because remember, a lot of times you have to work with these people, post sale. So if you are not getting along now, what's going to be like once we get, I call it it's done. The marriage is there. So you really have to use the process. I call it use the process to see if it's a good fit.
And one part of that.
Yeah.
I don't think it's usual. Realistically, when you're selling to an investor or another for a buyer, you're not leaving for 2 or 3 or
That's
4
true.
years.
That's true.
So you're talking to your new boss, and so if that relationship isn't good, we've had more than one deals with great deals and great parties, unhappiness later because they just didn't get along.
The best deals, I can generally tell at the closing if it's going to be a good deal or not. And it's because of the relationship that I've seen during the negotiation process. Not only with the parties themselves, but their advisors. So, and the business team, and how they address problems. And you guys, because of the AE space, it's really important that you're comfortable because again, you're right, that post-closing transition is really important, but it's still a professional business and it's very important. One final note on the letter of intent, because I think it probably goes here. I always tell people, if it doesn't feel right. If you can't figure it out, if they're not treating you correctly, if you're just not getting a good vibe, there's a hair on the back of your neck sort of a thing, it is okay not to do the deal. Sometimes better, I mean, most of the time, better deals come along. They just do. You don't have to buy the first dress. You just don't have to do that. There's some flexibility, but I call it the hair on the back of the neck test. All right. So once we sign a letter of intent, now you're really serious. Everybody has agreed to the bare bones of the deal, right? Purchase price, how we're going to get paid, all this stuff. Uh-oh, now what? This is what it's two distinct phases. And the reason I'm breaking it out is because for the last couple of deals, we could have probably done a better job of explaining due diligence versus drafting the documents. Generally in a letter of intent, it's like I said, it's the skeleton of the deal, but it has a paragraph in there that says, we're going to engage in due diligence for like 60 days. And if we really like what we see, we're going to continue and do the paperwork to get this across the goal line. So what does that due diligence look like? Okay, for those of you who, you're dealing in project documents, this is really time and paperwork intensive. The due diligence is generally a 3 to 10 page document of different areas where the buyer asks to see things. They want to see your corporate records. They want to see your tax returns. They want to see your backlog. They want to see your employee list. They want you to populate with all your insurance policies. They want to see your loss runs. They want you to upload all of your active contracts or contracts where there's $50,000 remaining so that they can check them for, certain obligations. And when I say that's intensive, it is. It's literally having someone do it, and they do everything mostly electronically these days. They have electronic doc boxes. So you guys use these, and they load everything up. But it is very time consuming, and because the group that is involved may be very small, the ability to give or ask people to help can be much smaller, right? So you might be having to put all the contracts together, and you're also still trying to keep your business running. So what I tell people is the due diligence is really, really paperwork intensive and upload intensive. And you're going to be asked to give them things again because they can't find it or whatever it is. But it is a long haul, but it also is giving the buyer the opportunity to fully vet the company. You've made representations that the company's doing X and now they're going to check it out. And that's what this phase is for, to make sure that, hey, they're happy with the deal. So once we're done with the due diligence and everybody's happy, I will say it is not uncommon that you make some changes to the bare bones of the deal after the due diligence process. It's just a natural thing. But assuming we're still dating and we're heading to the end, we're going to move into the next phase, which is the definitive agreements. The definitive agreement is the document of sale. It is typically called a stock purchase sale or an asset purchase sale. I don't see a lot of mergers, although I did a couple last year. What's the difference? A stock purchase sale is when the owners of the company sell the stock to the buyer. And so they step into the shoes of you, the owners. And that's really great for architects and engineers. I love that type of a sale. And that's wonderful because basically they take over, at least from a corporate perspective, all the assets and liabilities. Now we're going to sort out the risk allocation, but that's generally, they step into the shoes of being an owner. An asset sale is completely different. That's when the buyer takes substantially all of the assets, your contracts, your copyrights, your whatever they need on the corporate minute books, the furniture, fixtures, and equipment, anything that's more tangible, and they buy those assets and they pluck them and they put them into the buyer. So we call that an asset sale. Generally speaking, a stock purchase agreement is much friendlier. to a seller than it is to a buyer. And an asset purchase agreement, an asset purchase is much more tax friendly to a buyer than a seller. So some of the negotiation will be, if we're going to do an asset sale, you might want to consider, hey, I understand because we're doing this as an asset sale, this is going to cost me more money in taxes. Can you agree to pay a portion of those taxes? That's some of the stuff that we would go through. But you would have an asset document or a stock document. What does that document actually say? It's going to basically now flush out the letter of intent. It's going to be, here's the assets we're buying or the stock we're buying. Here's the purchase price. Here's how the purchase price gets paid. Here's all the reps and warranties. We'll get to that in a minute. And then risk allocation. So a little bit about purchase price. Purchase price can be super simple. From a seller's perspective, I say get as much cash as you can up front, because you may never see another dime post-close. But it is not uncommon to have a purchase price that is part cash, part note, or part earnout. Cash is easy. Everybody knows what cash is. Close, you get some cash at close. You might get the payment of the purchase price or a portion of the purchase price paid out via a note. And a note is just like it sounds. It has a balance. It's got some interest. They make payments over a period of time. And then there is an earnout component. For those of you who are on the buy side, I know buyers love earnouts because it's dependent on how the company does over time. But an earnout from a sell side can be problematic post-close. Why do I say that? Sometimes if your buyer has not done this, or it is not clear or not clearly defined how we're going to calculate the earnout, and however that's calculated, if there's thresholds, if there's bonuses, it can cause you to, either not be able to make the earnout, lose out on money, lots of fighting. A lot of the earnouts I see are companies that are coming in and they want to get at the market. So there's like an Irvine office or a Santa Ana office. And so the earnout will be based on the gross revenue that's coming into the Irvine office, because the Irvine office is where the selling entity is. But what they forget to do is, well, what happens if there's extra overhead coming in from the buyer? What happens if we're being pulled off projects and being asked to work on the other buyer? How does that work? And that can cause a lot of consternation. One of the things we've started putting in our agreements, whether it's an asset sale or a stock sale, is a provision that basically says seller agrees not to do anything to basically frustrate the purpose of an earnout. Because I have actually seen that where they come back in, they're like, we own the company now, and I've got a seller who says I can't earn my earnout. You're getting in the way. And earnouts are probably the most frequent issue that comes up post-sale that would end up in litigation. So assuming you get through that, the agreement will also flush out risk allocation, reps and warranties. The most important thing you will spend, and you'll spend most of your time, is reading Article 3. It's always Article 3 of the agreement, which are reps and warranties about how the business has run in the past. You are properly capitalized. You are the owners. Here's the board of directors. Here are my contracts. I've performed all my services in compliance with all applicable laws. I've paid my employees on time. I paid my taxes on time. And I will kid you not, the last deal I did had about 20 pages worth of reps and warranties. But why does the buyer ask for that? The buyer asks for that because you know your business better than they do. And they want to be able to say, you told me that you file all your taxes on time. And so if there's an issue post-close, they will say, you told us it wasn't true. And they may have contractual rights and remedies against you. What else is in the agreement? Indemnification. Well, what happens what's your biggest issue post-close? For you guys, it's your professional services, a claim coming up on your professional services done for services rendered prior to close. The agreement will address, similar to your professional services contracts now, who is responsible for those and how are we going to tender them. That will go into the liability tail insurance policy. From a seller perspective, I think personally, the easiest and most cost-efficient way, provided the selling company has a really good loss run, is to add the selling company to the buyer's professional liability insurance with full prior acts. Why do I say that? There's no hiccup in coverage. The professional liability policy, provided the buyers continues to be in business, will be perpetual. It's for full prior acts, so it covers all the services you provided. And there's no issue about which policy should cover. The only thing you really have to negotiate is who's going to pay the premium or the deductible on those pre-closing services and for how long. I'm not a big fan of the extended reporting period. The big kids do belt and suspenders where they require the selling companies to do extended reporting periods, and then they put their professional liability policy on top of it. Not uncommon. I've seen that, like I said, with the big kids. But for me, from a selling perspective, adding the company and basically the company as a named insured to the buyer policy is the easiest way to handle these things. And then we touched a little bit on this on the shareholder side. The buyer is buying you and trying to take you off the market. They do not want you to get back in the game for a period of time. So another hotly negotiated issue will be, how long are they going to put you on the bench? 3, 4, 5 years, 2, 3, 4, 5 years. It's not uncommon. 3 is very common. Sometimes banks make it 5, but that is what I try to tell people is they're paying you a lot of money so that they can grow and take over your business. And they don't want you going across the street and opening Joe Schmo, architecture too. So that payment is to place you on the bench for a certain period of time. And then there are other documents with the definitive agreement, including employment agreements. There's all sorts of things that we put in that can be part of the process. But the definitive agreement is, again, we talked about due diligence being very document intensive. The definitive agreement negotiation is very time consuming. You're going to be doing a lot of the same things that you did in due diligence that you're going to do in the definitive agreement phase. And I will tell you, you will get transaction fatigue, and it's okay. Just know it's out there. I just try to tell you that it can be fast paced, and people can get you can have issues come up that you didn't foresee. So it's just, like I said, it's a process. I've been through it. So for me, I'm very comfortable with it, but you guys not having gone through it before, that's our job to say if it's normal, this is moving along the normal course. But provided we get all these things taken care of and everybody's happy and we feel like the risk has been fairly allocated, we close and there's a big party.
That's my part.
That's your part. So do you want to do the light? Do you want to do last slide? So my goal was to try to introduce you to the third-party external sale condensed version. I could talk for another hour on it, but some people decide to do a mergers and acquisition that's a little bit lighter than this, that not as full board as we were talking about.
Yeah, let me go back. I mentioned a couple hours ago that you've got problems with closing down a practice because you lose your tail coverage, et cetera, and you can't sell get your ER or AR, you can't sell your goodwill. One way around this for small firms or whatever, which we have actually backed into, I think, but it works, especially in the current insurance market, is I don't have a good comparable thing here. In the law business, we often have of counsel attorneys, very good attorneys, usually partner level attorneys, but they're not going to go into the partnership as such, but they have an association with the firm where they're as much attorney here as anybody else, but they're of counsel. I mean, we join forces and they participate here. There's kind of of architect, I guess you'd say, scheme that's fallen into place, and it does work, where somebody who's had a successful practice but closed it down and it's not large and they're not they don't have the internal team to sell it to, and they're not going to go through a whole mergers acquisition deal to sell what they have, will join another firm late in their career Sometimes they get even get added to the name or something. I've seen that done. So they join this firm. And then what you can do is you bring your people into there. And so usually, especially smaller firms, want to have a place for them so you can take care of your people. You also keep an active practice so you can use your client base. You can get your goodwill. You probably can collect your AR. You have that going here. And then it's perfectly feasible to have that the buyer company, the company that's being joined, to add the selling company on their insurance policy with full prior acts. So basically, you just got your tail coverage that you lost. And then someday there'll still be a transition problem for the owners of the new company, but it's not your problem anymore. You simply get on their boat, and then wherever time later, 3, 5, 20 years later, the whole pile looks up again. But for your career, that's a way out and gives you add maybe 3 or 4 years to your practice.
Yeah, and I think where I've seen it is that the seller is not interested in getting a premium on the purchase price. What he is interested in is having maybe an increased salary for a few years, maybe, overcommit to the 401k, but really, really important for him or her or them to find places for their people and their clients. And so it's a totally different perspective and approach to a typical third-party sale where you're really trying to get the most value as you can out of your firm. So, and so that was, for people that works too. So they may have already pulled out all the money they want. So,
and that
is it.
I think we've done it. Complaints or whatever, that's fine. Otherwise, we'll sign off. I think we'll sign off.
Yep.
Thank you both very much.
Right.
Great seminar.
All right, thanks, guys.
Thank you.